update y'all on. This is pertaining to Desiree Perez and Demore. There has been a court order for Demore that I wanted to read out to you all that just dropped literally within a couple of minutes ago. So let me go back to the very top. So as y'all do know, there were two cases open. There were uh two cases that was simplified to one case. As y'all do know, it was Demore versus Desiree and then Desiree versus Javon. So it talks about that in the first beginning of the court document. So let me start reading. This cause is before the court on Rock Nation's motion for order to show cause why plaintiff, should not be ordered to remove social media postings and not be held in contempt of court. Desiree Perez's motion for special order regarding social media postings in violation of court order. Go to court document 125. In certain parties, motion for order to show cause while Javon Hadley should not be ordered to remove social media postings and not be held in contempt of court. Look at court document 138. Collectively, the motions. The Honorable Beth Bloom, United States District Judge, referred these motions to the undersigned United States Magistrate Judge for a report and recommendation. So for y'all that do not know, that's just not joining in, this is a report and recommendations court document. Okay. This is pertaining to Demore and Desiree Perez. All right. So on June 25th, 2025, Judge Bloom entered a special order which provided in part no party or counsel for the party shall give or authorize any extrajudicial statements or interviews relating to this case that a reasonable person would expect to be disseminated by means of public communication. Parties in counsel for parties must also refrain from giving or authorizing any extrajudicial statement to a media outlet and likewise refrain from posting on social media or other public platforms extrajudicial statements related to this action that are intended to influence public opinion regarding the merits of this case. And so it shows, go back to docket 112 and 7. The motions at hand asserted that Demore and Javon Hadley posted extrajudicial statements on social media after entry of Judge Bloom's special order. I convened I convened a hearing on July the 31st, 2025, at which Demore and Javon Hadley were present in open court. Counsel for Mr. and Mrs. Hadley acknowledged that his clients published a few social media posts, and if y'all do not recall, it was 17 in total. I had read that back in June, but let's continue. After entry of the special order, but argued that they published the posts before they were aware of the special order's existence and understood its restrictions. At the hearing, I asked counsel for Mr. and Mrs. Hadley whether he believed that the special order prohibits any party or counsel from instructing, asking, facilitating, or encouraging a third party to publish extrajudicial statements about the case and from providing a third party with information in the hopes that they will publish an extrajudicial statements about the case. Counsels agreed that this is the proper interpretation of the special order, given that all counsel agreed on the foregoing interpretation. I impressed upon Mr. and Mrs. Hadley's the conduct that the special order prohibits. During the hearing, Mr. and Mrs. Hadley, let me scroll down, voluntarily removed all social media posts that the movements identified as posts in violation of the order, except for one post on Mrs. Hadley's X account. The movements contemporaneously reviewed the social media accounts and confirmed that, except for the one post on X, all violate posts had been removed. All parties represented in the court that the X platform would not allow Ms. Hadley to remove the one remaining post with the click of a button because the underlying video shared by the post is the subject. I'm sorry, I'm reading too fast, y'all. Hold on. Let me get myself situated. Because the underlying video shared by the post is the subject of a copyright takedown notice. For this reason, the parties have jointly proposed that the court enter the order attached hereto as Exhibit 1. And I do have Exhibit 1, so when we get finished, I'll read that to you. I have reviewed and proposed order and confirmed that this does not purport to order any non-party beyond the court's jurisdiction to take any action. I find that the proposed order is appropriate and will expedite the resolution of this collateral matter. Accordingly, I respectfully recommend that the court enter the party's proposed order attached hereto as Exhibit 1. Finally, on the matter of what sanctions to impose, if any, without court intervention, the parties resolved their dispute regarding the movant's request for fees and costs incurred in bringing the motions to compel compliance with the court special order. The parties agreed that Mr. and Mrs. Hadley jointly will pay a total amount of $2,500 to the appropriate trust account of Holland and Knight LLP no later than 10 months from now. I respectfully recommend the following. The court enter the party's proposed order attached hereto as Exhibit 1. Rock Nation's motion for order to show cause why plaintiff should not be ordered to remove social media posts and not be held in contempt of court, go back to docket 113, be denied as moot. Y'all listening? Desiree Perez's motion, Desiree Perez's motion for special order regarding social media postings in violation of court order, go back to docket 125, be denied as moot. Okay, there's a little insert at the bottom of this page. On several occasions during the hearing, counsel for Mr. and Mrs. Hadley seemed to contend that compliance was impossible without third-party intervention. I reminded counsel that Mr. and Mrs. Hadley bear the responsibility of bringing themselves within compliance of a court order by any means necessary. No one disputed that unilateral compliance is possible because Mr. and Mrs. Hadley could delete their social media accounts. Okay, let's go to the next page. Certain parties motion for order to show cause why Javon Hadley should not be ordered to remove social media postings and not be held in contempt of court be denied as moot. A party shall serve a file written objections, if any, to this report and recommendations with the Honorable Beth Bloom, United States District Judge of the Southern District of Florida, within 7 days of being served with a copy of this report and recommendation. Failure to timely file objections will bar a de novo determination by the district judge of anything in this recommendation and shall constitute a waiver of a party's right to challenge on appeal the district court order based on unobjected to factual and legal conclusions. So that is that. And at the bottom of the page, it says the period of to subject is shortened to reflect the party's agreement to the relief recommended herein, and in effort to effectuate their agreement with respect to the court's entry of the proposed order as expeditiously as possible. Then there is an exhibit at the bottom. Proposed order directing that certain reposts on the X social media platform be removed. This cause is before the court upon defendant Rock Nation motion for order to show cause why plaintiffs should not be ordered to remove social media postings and not be held in contempt of court for violation of court order. Docket 113. The motion. After reviewing the motion, having heard argument of counsel for Rock Nation and Demore Hadley at a hearing on July the 31st, 2025, the hearing, and being otherwise fully advised in the premises, it is hereby ordered as follows. Okay, y'all listen. In the motion, Rock Nation has requested the court to, among other things, direct Damari Hadley to remove certain social media posts from the X, formerly known as Twitter platform, X platform, because they violate this court's order on expedited motion for special order regarding extrajudicial statements. Go back to docket 112, special order. During the hearing, Damari Hadley was successful in removing the majority of these posts, but reported that she experienced technical difficulties in accomplishing the removal of the one repost of a third party's post on the X platform. Based on the court statements during the hearing, Damari Hadley agrees that the repost from her at Maury Hadley's account of the following posts should be deleted and removed from the X platform. And then it does give the post ID of that post that she specifically made on June the 25th, 2025 at 7:03 p.m. So here it is. Accordingly, it is hereby ordered and adjudged that Damari Hadley must delete/remove the repost from the X platform because Damari Hadley continues to report having technical difficulties in deleting the repost. Rock Nation, LLC, and Damari Hadley are directed to provide a copy of this order to X corporations and advise X corporations to remove or delete the repost because but not in the underlining post because the repost is a violation of the special order. So there you have it. It's showing that they are to submit on both sides, Rock Nation and Damore. They must send a letter or a copy of the order to X for them to, on their end, delete that specific post that Damore made on June the 25th. So if y'all were able to scroll over to Twitter or X, I'm not sure if it's still there. It'll probably take a day or two from them submitting a message. But if y'all go back to her June 25 post, you would probably still see the post up. So that is that. Y'all know me. Give me a few minutes. I will have this put on X. So it looks like due to them having to actually do this hearing, Javon and Damore agreed to pay $2,500 to the Holland and Knight LLP. All right. And also, if y'all did not catch, in certain posts, they were taken down other than that one post. But then if you actually go back and you look on the Rock Nation side, Rock Nation's motion for order to show cause, it will be denied as moot because on Damore's end, she just went ahead and deleted the post. Okay. So y'all give me a few minutes. Let me put this on my platform and then y'all be able to divulge in it. Okay. Get money. Yep. 2,500. 2,500, y'all. Well, mm, mm-mm. Also, did y'all peep for the $2,500 that she has to pay back? She has up until no later than 10 months to pay back that $2,500. Yep. All right. I hope y'all have a good day. I hope y'all have a great day. It is about to storm over here in the woodlands. The clouds it's getting dark as hell. I'm about to go outside. Y'all know how I am. But before I do that, let me go ahead and get this posted for y'all, okay? So y'all give me a few minutes. I hope y'all have a good day, a great day. Stay safe. Don't be dehydrated. Stay hydrated, y'all. It's hot out here. It's getting up to 90, 100 degrees. Make sure y'all stay hydrated. Get you some fluids, some water, some electrolytes, and rock out, y'all. All right. So I hope you have a good day, a great day. And as I always say, when you lead with integrity, you never ever have to worry about somebody questioning your loyalty or your intentions. And with that being said, I hope y'all have an amazing morning and get you something to eat. All right. Drink your water. All right. Bye bye.